All right, welcome to the Creative Finance Collective. If you're just joining us, we're getting together to talk about all things creative finance related. If you have any questions, make sure to post them in the chat. We're taking questions throughout the entirety of the hour. That's how long we'll be here. We got a few folks here and a few folks on the way. Alan, I'm curious, are you a Rangers fan or are you a Houston fan?
So I got to be Rangers.
Oh,
I'm born in Fort Worth.
I haven't had an. I don't know if you watched that game last night, and I haven't had a chance to talk with Sean about it. But I feel like the refs made a terrible call in the ninth inning that, man, may have ended that game differently. That's wishful thinking, maybe on my part, but I was pretty upset with the officiating. What'd you think about that, Sean? You know what call I'm talking about.
Uh-oh.
Hey, Sean, your audio. Oh, you're on mute. You're on mute. There
Yeah,
you go.
it was a ball, but there was another pitch earlier in the at bat that was a strike that the umpire called a ball. I think it was a makeup call.
A makeup call. Oh, that's an awful bad time for a makeup call. Hold on, Scott's trying to get on. Let's see if he's had success. Are you there, Scott?
We're still trying. Can you see us, Andy?
We can't see you,
Can
but
you hear us?
we can hear you just fine. So if Scott wants to just appear and talk while we're
Okay, I guess he'll have to do that. I've got our resident IT girl, and she's trying to figure it out.
Yeah. So no, that's all right.
So if he's just 2 minutes away from being here.
Oh,
So
okay. Yeah.
if you see him, if not, we'll just.
If we don't see him, just tell him to yell loud, and we'll hear him.
All right.
All right. Sounds good.
Trust me, he'll pipe in, I'm sure.
I'm sure he will. All right, so we'll have Scott in a second. We got Drew here also. Drew, thanks for joining us. We're talking about the World Series and the Texas Rangers and the terrible officiating. And oh no, it sounds like there's another Rangers fan.
There is. Come on. We're big fans here in Dallas.
Okay, so is that where do they draw the lines? I've never understood. You folks in Texas educate me, but where do the Houston fans? I guess obviously Houston, the folks in Houston, but is there a line of demarcation in Texas that decides whether you're a Rangers fan versus a Houston fan?
The 30
kind of the people in Dallas more so. I don't know, Alan. What about Austin? Are you guys kind of in the middle on both teams?
Well, I'm from Fort Worth, so I'm definitely Rangers. I don't know if there's a 38th parallel somewhere. Might be.
Yeah. So.
Well, I will say it's been a good series. Like every game is, except for that second game has come down to it, and so we'll see. Hopefully it goes 6 or 7.
Yeah, I have a feeling they feel pretty equally matched. I have a feeling this is easily one of those that could go 7 games. But we'll see. We'll see how that goes. But they're young, fun teams to watch, so that has been good. Drew, it looked like you were trying to talk. I'm not sure.
Sharing scary stories.
Oh, yeah. Well, the scary story is that the Diamondbacks are down 2-1. That's the scary story. So we want to flip that tonight. How things in Georgia, Drew?
Obviously, Colts come out. I don't watch too much of sports, unfortunately. So just for the parent, everyone's mad at Phillies for stupid, but that's about the extent of my knowledge.
Yeah, Braves fan. Well, I was talking earlier with Alan. Alan had a few things he wanted to talk about. You've got a bone to pick with solar leases.
Well, just wondering what we're doing with those things. I've got a bunch of people saying, "Hey, fix this," because that's destroying the viability of a transaction. I've heard some scuttlebutt about people trying to get that UCC lien disassociated from the property, so that allows them to get a loan or a refi or something. But anyone wrestling with these things?
Well, I'll just say I was talking with Scott Horne just last week a little bit about these, and I was kind of surprised to hear that it sounds like in Texas that, and I don't know that this is allowed, but they're literally recording UCC1 financing statements in like the county property records,
Yeah.
which would be unusual here. I mean, if it's a personal are you seeing that, Sean? I mean, a personal
Yeah,
property
no,
lien is supposed to
they've
go
been
in the
doing it. They
Secretary
do
of
it as
State.
fixture filings, which means they're, and that's the interesting thing. And Elizabeth and I have done some research on this. Is we've had clients who have purchased property at trustee sales, and then they went to sell the property, and the title company's like, well, there's a fixture filing on there. And we're like, yeah, it was after the date of the deed of trust that was foreclosed. Like, it's no more. And they're like, oh, no, no, no. And so we've kind of gone back and forth. We were right. We got it fixed and closed. But the solar companies, I think, are taking the position of, well, these are personal property, and so we have a UCC lien against the personal property. And so we're saying, okay, well, that's fine, but you shouldn't be recording a fixture filing. And if it's a fixture and you've recorded a fixture filing, well, that should be wiped out in a trustee sale because now it's attached to the property. It's a fixture. You can't have your cake and eat it too. You can't file a fixture filing and then say, oh, but we retain our personal property lien. Well, no, it doesn't work that way. I mean, that's my position. Like, if you're going to file a fixture filing, okay, file it, but now it's a fixture. And if we foreclose, we wipe it out. And guess what? We own your solar panels and there's nothing you can do about it. I mean, do you guys disagree with that? Huh?
Y'all are clearly different than us. We regularly are filing both in the UCC1 in the state index and filing the fixture filing just in case, because sometimes we're not sure whether it's personalty or whether it's realty. Right. And so they file in both records just to cover their bases, basically. So that is what we see here is you have both the UCC1 in the UCC index. And nowadays it's all rolled into, if it's a commercial file, especially it's just written into the deed to secure debt, security agreement, assignment of leases and rents, and fixture filing are all one giant, document that, rolls it all in instead of filing multiple things. You just file one and you're secured from both angles. I didn't know if you were talking about on the residential side with the solar panels or the commercial side.
No, on the residential side. And I will tell you, Drew, they file both a UCC with the Secretary of State and they file a fixture filing with the county recorder's office. But let me ask you this and see if you agree or disagree with this. If a court were to determine that the UCC, that the solar panels, when they were installed on the roof of the property, they became fixtures, they became affixed to the real estate, and there was a foreclosure by a senior deed of trust, that entity, or not that entity, the solar company is out. They have no further lien against those solar panels. Now they may have a claim, a collection claim against the, tenant or the original borrower. That's a whole different story. But as far as their ability to have any type of lien and right to those solar panels, if it was truly a fixture, is wiped out by a foreclosure of a senior deed of trust. Would you agree with that?
I would agree if the courts were to take the position that it was in fact a part of the realty at that point. I've seen a case when I was a young attorney, it had to do with a school and it had to do with providing sewer services to a school. And we represented the GUS board, right? And the position is the sewer pipes underneath the school do not belong to the school and they are personalty, still owned by the GUS board. And our guys proceeded to start ripping sewer pipes out of the ground across the school property. And of course, you've got two quasi, one's government and the other's quasi-government entities involved. So it was an interesting thing. I've had another case where we had a hot water heater in a house and it was bought at foreclosure. It was a HUD home. It got foreclosed. HUD picked it up and sold it. And there was a UCC and a UCC fixture filing on the hot water heater. And the UCC was in favor of the city. The city had a program for hot water heaters or whatever. And their position was we own the hot water heater, right? Exactly to your point. Fortunately, it was small, and my client said, well, fine, you come pick it up on the side of the road on Tuesday, right? That was his
Right.
solution. But I mean, it gets complicated because the court, you would have to get the judge as a matter of law to state that this is now a part of the property. It's now an improvement. It's no longer personal property. And obviously, the secured party is going to argue whatever's most advantageous. So I'd walk into court just like we did with the sewer thing and say, it's our pipes. It may be in your dirt, but it's still our pipes, and we're going to take them out. And if it's advantageous to say that it's, a fixture to the land, and, oh, hey, I foreclosed and I should get it and it's not yours, you're going to argue it. But I think it's going to depend on the judge you get.
Well, let me take it a step further then. So in Arizona, we have a wrongful recording statute, and it says that if you record something that contains any type of, material misstatement, anything inaccurate, etc., that you're subject to automatic statutory damages of $5,000 plus treble the actual damages, or not plus, or treble the actual damages, whichever is greater, plus attorney's fees, plus costs. So if I have a solar company that goes into court and says, oh no, we still have a lien against the solar panels because they're personal property, they're not fixtures, they're not affixed to the property, and we have a lien because they're personal property, and that's the argument they make, haven't they just wrongfully clouded title and recorded a document containing a material misstatement by saying that it was a fixture when they're now in court attesting under oath that this is personal property? Well, if it's personal property, why'd you file a fixture recording? Because it's not a fixture, and you should have never recorded it, and the recording was unlawful.
Unless, here's the other side of it. Unless, like here in Georgia, let's use that same example, and your borrower goes to sell the property with the solar panels on top of it. And obviously the solar company wants to get paid off if their borrower no longer will have title to the property. And so we filed it as a fixture filing to ensure, because again, as title, if I see a naked UCC1, right, that's not tied to the property anyway, I'll ignore it. Right. Because I don't care. Yeah, you're a developer. We've got UCC1s filed on your earth moving equipment. It doesn't make a difference to me for the property. So if you just have a regular UCC1 that's just like solar panels, I may be like, all right, who cares? But if it's a fixture filing, it all of a sudden becomes a proper title, right? It's now tied to title. And like we just said, you may not even be sure whether it's a fixture or whether it's personality. And so, you're trying to hedge your bet. So, I see your argument. But at the same time, I can see theirs too and say, well, we're not 100% sure either, but we want to make sure, Your Honor, that when the borrower sells this house, that we get paid off just like any other bank, or right. It's still
right. So they're recording it
that we literally will remove from the property itself. When these panels are bad 15 years from now, we'll come and take them off. Or if they're bad, just like you have window break, well, I'll go replace it.
Well, so they are recording the UCC fixture filing to cloud title. I mean, that's essentially what they would be doing. They would be arguing like, yeah, we probably don't have a right, but we're going to do it just so that, we get paid or whatever. Why don't they just, in my view, they should just get a deed of trust or something, and have the borrower execute a deed of trust and secure their right to repayment, via deed of trust. Then it's pretty clear when the senior deed of trust forecloses that it just wipes out any, lien against the real estate for those solar panels. Now we got it resolved on the one, but the title was, when we were trying to sell it, title was like, no, those they still have a lien and it's personal property. So, and basically saying we can't close. And we're like, well, like you, Drew, you said, well, I don't care if it's personal property. I could care less as a title, examiner, like just let it go. But title in our one situation was like, no, we're not going to let it go. And they were, saying, no, we're going to put it as an exception on the policy and the whole thing. And it became a real mess. We got it worked out. But I don't like the fact that these solar companies record both a personal property lien and a fixture lien, because I think they should have to choose which one they want and then deal with the consequences of that. I don't think they should have their cake and eat it too. That's just my view.
Well, that's what counts, isn't it?
What?
Having their cake and eating it too?
No,
that's what they want to do. What?
I just said your view is what counts, Sean. Come on. You like that.
Yeah.
So I hope you all
Say,
like my
I see that, but
costume
it's
here
going to put
today.
everyone in trouble because our lenders, our commercial lenders, do the same thing, right? They file the UCC and then they file the UCCFF, and they cover themselves on both sides.
Well, so my first question is can y'all guess what my costume is?
No.
Ghost, because I can't see you.
Black streak.
Close enough. Anyway, so I don't know if Alan has spoken up there. It looks like Mr. Dapper Dan in his little hat or not, but
Yeah, he's dressed up for Halloween. He told me. There he is.
I'm Peaky
Look at
Blinders, Tommy Shelby, baby.
Tommy Shelby.
Yeah, Peaky Blinders.
Really?
No one watch TV anymore.
I
No.
know what you're talking about.
No.
Help us peons out for a minute.
1930s Irish gang program. Pretty good. Has that Cillian Murphy. How do you pronounce his name?
Yeah.
Yeah.
Cillian Murphy from Oppenheimer.
They don't know either.
I
Who is it,
Cillian.
Libby?
think that's close enough.
What'd
I'm a
you say?
gangster. Just a gangster.
Talking about solar panels, I don't know where you guys have gone. And I know in different states, different things. Of course, here in Texas, and I'm sure it's the same everywhere else, the UCC liens obviously don't attach to the real property. But our title companies in Texas go, we don't care. We want them removed regardless,
Right.
which is what's problematic.
So let
And-
me ask a question then. So let's say it's UCC lien and seller's distress. They sell the property. Everyone stops paying that solar panel note. Do they come back and get their solar panels, and can they sue the seller?
They
Well,
can sue
one,
the seller,
yeah, they can sue the seller because they signed the note.
but
Whoever
they're not
signed the
going to
note.
take the solar panels off the roof because they're scrap metal at that point, and it would cost them more to put the roof back into a weatherproof condition than the panels are worth.
But they have the right to come and take their panels.
They do have the right
do.
to do it. They're never going to.
And then when they're not made whole with recovering that property, they can then go and sue the seller.
Correct.
Yep. Well, what I think, guys, and this is just me as a lender talking a little bit for a moment, that, what I see out there is it probably costs the installer $5,000 to install the solar panels. They in turn charge their borrower $30,000 on, a 30-year note at X interest rate. Then, of course, they sell that note to the California lenders at $15,000 per se. And it's kind of like the old mobile home game, I think. And this is just hypothecating a little bit here, where the same lenders out in California, other places like this, who did the mobile homes, they had to run all their algorithms going, there's going to be a certain number that pay off in full. There's going to be a certain number that pay through a certain number of months. We may sue a few people here and there and win some things along the way, but they're playing a game along the way because they know that they don't have a lien on real property. In fact, just this last Friday, I was speaking to a solar panel company called Good Leap. Y'all may have heard of them or not, I don't know. And it was my initial phone call before sending a demand letter to sue them. And I was talking to this young lady, and she said, we'll execute a release to the real estate, no problem. I went, really? And so I did a release of the UCC lien as to the real estate only, sent them a nice letter, and we'll see what they do. Now, in that letter, I simply stipulated that if they don't execute the release as to the real estate, that we will intend to seek other legal remedies because we would sue the solar panel lender at that time for clouding title inappropriately. That's just a step you don't want to take, and we can avoid it, obviously. But at the same token, I sent out a second one at the same time to a different solar panel company. I just want to see if they'll do the same thing or not. And if not, then we'll take the legal route. I just can't imagine they'd let it go that way. But, I'm not sure about y'all, but I've actually called these guys. I've offered to have them come out, remove the solar panels, do whatever they want to do, get their stuff back, all the equipment, and never, ever have they done it. And some of the fellows here in Dallas who I know who own solar panel companies just go, there's no way. Once they're installed, they're done. They're just not going to do it.
Does Texas have a fixture filing like some of the other states, or are they literally just recording UCC1 financing statements?
Well, they can record their UCC1 in Austin to secure their interests, whether it's in a solar panels or on a car or a boat or whatever it might be.
Well, yeah,
right?
I don't mean just in the personal property. I mean, like, are they recording it in a way to create their UCC1s in a way in the county records to create a real estate lien?
Yeah, no, I don't think they can do that. And then the biggest problem is going to be, I don't think they could file a lien on a homestead anyway, be it a fixture filing or something else of that nature, not in Texas.
Right.
Yeah, they file them in Arizona all the
Say,
time.
y'all's laws
with
in
every
Texas are a bit different.
solar. Yeah.
Yeah.
So Drew, I'm curious though, what would your position be if, you know, in doing an escrow and examining title, if you had a senior mortgage, deed of trust, trust deed, foreclose, and would you view the fixture filing as being wiped out? And if it were junior to or subordinate to that deed of trust or mortgage?
I would certainly view the fixture filing side as being wiped out, but I would not view the UCC1 in the personal side as necessarily being wiped out. And so a great example would be like an HVAC or something, or as I said, this one weird one in Trussville, Alabama, where it was the hot water heater, right? And so, in that case, I just pointed out, hey, you might want to reach out to the city. And of course, the city said they still owe us $800. And my guy was like, pick it up on Tuesday. It'll be on the side of the road. So I would definitely point it out to the transactions. And we have something that's kind of similar here. An issue we're dealing with now is water and sewer. It's not technically a lien against the property, right? If it's not against the owner of record, but that doesn't stop the City of Atlanta watershed from just point blank refusing to turn water on. So we point out to the parties that, hey, it's not a title matter, right? This is not a problem of title, but it is a real problem for you as the buyer or you as the seller, because at least part of your property might have an issue. In this case, it would be water, or in the other case, it was the hot water heater. So it's not a problem for title. I can close. Just be aware that you might have issues with one of your providers, or you might lose your hot water heater, whatever it may be.
Right. So if the fixture filing is released by a senior deed of trust, then that leaves the solar panel lender, lessor with simply a personal property lien. And I know in Arizona, and I don't know if this is in Texas or Georgia or Alabama, but in Arizona, you cannot trespass or breach the peace to repossess personal property. And so while the original lease agreement or the original loan agreement may have given authority by the borrower, the lessee slash own property owner at the time, right? The current property owner to, they may have given that lender or lien holder the ability to go onto their property, so it wouldn't be a trespass, and remove the solar panels. But if the property has been transferred and conveyed to a new owner, or there's been a foreclosure, of a senior lender, well, then it's no longer owed by that party that gave their consent for the lender to go on to the real estate. So I'm guessing, and I'd be curious everyone else's thoughts, but I think in that scenario, not only could the solar lender, they couldn't go onto the property to repossess their panels, they would actually have to go and get a court order of replevin, which would then allow them to do it. So they would have to file a lawsuit and take it all the way through in order to get the opportunity to, with probably assistance of the sheriff, go on and take down those solar panels, which makes it even more cost prohibitive.
Sean, there's another issue too. I think in Arizona, generally, the courts are pretty aggressive with creditors about kind of election of remedies, right? I mean, isn't that what this feels like ultimately, an election of
Right.
remedies?
File get moved. Everyone have a good Halloween. Sorry, guys, I got to jump.
All right, have a
Okay.
good one.
See you, Drew.
Bye.
Yeah, I think it's an election of remedies, but I think, if the fixture filing is removed, I think that the only thing that the lender or the creditor for the solar panels, the only thing they could do, not that they want to, like Scott and Alan pointed out, I don't know that they would ever want to get those back anyway, but to the extent they wanted to get them back, they would have to file a lawsuit. And I don't think they could recover attorney's fees for filing the lawsuit and pursuing the lawsuit, because there's, at least here in Arizona, there's no contract between the new owner and that, company. And so all they would be doing is going to recover their materials. So I don't know. Alan, how have you been dealing with these though in your subject to transactions? Has the, buyer been assuming them? Has the buyer and the seller just been like, forget it, buyer beware, the panels are there and they may or may not get picked up? I mean, what have you been doing? Do you have an addendum to your purchase contract that deals with these solar panels? How do you guys deal with them?
So it's across the board with the majority. I guess when there's enough equity, what have you, of the buyer assuming those solar panels, and we it's handled in special provisions. Buyer to assume payment of solar panels, and I incorporate that into my wrap documents, which I don't really like the way I'm incorporating it right now. And then we've also seen where the buyer says, seller, you still owe for this. And they get an unsecured note against the seller, which that's probably worth about 37 cents. I've even seen them share they'll share the cost, going forward. So, but the majority of them, when they close, the buyer's taking that over. But then I would assume there's dozens and dozens that the project doesn't go forward. The transaction doesn't close because of this solar lien.
Yeah.
Oh, interesting.
Well, I'm just going to pipe in for a minute. So if I'm the investor buying the home, let me just use me as an example. I'm not taking that solar lien subto in any form or fashion. Mortgage lien, yes, but I'm not agreeing to pay the solar lien. Now, from there, I'm still going to do my best to remove that solar panel lien from the property through some mechanism, some release, whatever is going to work at the end of the day. But at the same token, if I'm going to market that home for sale to a back-end home buyer, obviously we're going to give them the option to come in and assume that solar panel, lien. And if after the wrap sale has occurred, the solar panel company wants to come in and file a new UCC, go for it. So long as that solar panel lien is behind my wraparound mortgage, so that if I ever foreclose, I extinguish that UCC lien completely. So I only want to deal with it once. And obviously, as Alan said, there are some times when buying these, the investor will walk away, or the wraparound buyer will walk away, because it is an encumbrance. Even though it doesn't attach to the real property, to remove it from title, you got to pay it. Now, if you're closing outside of title in just a law office closing, we can put it on the affidavit of debts and liens, close the deal, move on, not a problem. It's just, you've got to or at least you want to disclose here that, it is going to be an obligation to be handled appropriately downstream at some point in time, should there be a refinance or a sale of the property.
If you're just now joining us, this is the Creative Finance Collective, and we're talking about things related to creative financing right now, solar panel leases and the types of liens that they create and the ways that we deal with them in a subject to transaction. But if you have questions, make sure to put them in the chat. We're taking questions for the entirety of the hour. So yeah, solar panel liens complex. Alan, you mentioned earlier too this thing you were calling hybrid wraps. What is that?
Yeah, so we're running, and I don't know which guru came up with this, but we're running in situations where uh, someone comes to purchase a property, and it would normally just be a wrap sale, a bigger note created around the smaller note. But what they're doing is they're breaking it up into two. So the investor's saying, well, I'm taking it sub two, and then on the equity, we're creating another seller finance carryback note. And I mean, I don't like them because they create complexity, increased cost for closing, et cetera. But I'm just wondering if y'all are running into them, and if you're maybe cramming these down into one note possibly, or if you're not seeing them.
So yeah, so on the disposition side, we're just doing one note unless the investor plans to want to sell off, a note, then we'll do two notes, one for just a performance, and then one for that they can sell off that's financing the equity or whatever. But most of the time they want a higher interest than what they're paying under the existing loan anyway. So we just generally will do like one note, at a set percentage, and then provide that payments are made to a servicer and the servicer pays the existing loan, and then, that type of thing. On the acquisition side, I have one note that I use, which has two components. The first is, so the monthly payment is equal or identical to the amount of the existing loan plus whatever amount is going to be paid on the equity, or what I call the additional principal amount. And so it's basically a performance note plus, and then you have an amount that's going to be paid every month if the seller's financing a part of their equity, if that makes sense. So it's only one note, but I don't try to amortize or figure out what that would look like if, let's say the existing loan is 3%, but the seller on their carryback wants to charge 5%. I don't try to do the math and figure it out. I just say, okay, identical to the existing loan plus whatever the amount is if they're financing 100,000 plus whatever the payment would be on 5% of 100,000 amortized over 30 years or interest only or whatever, if that makes sense.
So you've got one note and one deed of trust for that hybrid closing.
Yes.
So I was using one note whenever it was what I call a simple carryback, a lump sum payment in 2 years, or 4 equal payments of X.
Mm-hmm.
But whenever it got to the point of having a different amortization table than the sub two portion, I've broken them down into two notes and two deeds of trust. But I like your idea. Maybe I have just a regular note with the equity portion, and then also, by the way, you're taking the sub two portion also.
Correct. Yeah. So it's one note, and it just says your monthly payment is an amount identical to the existing loan plus, and then I put in whatever the payment's going to be made on the equity.
What on your deed of trust, when you're identifying your note and you have the amount in there, what are you putting?
Principal balance of the existing loan plus whatever 100,000 for seller, if that's what the seller is financing on the equity. So that's the amount that I put in, and I define the existing loan in the deed of trust. So, the loan secured by the deed of trust, recorded on this at this, I cross-reference the document. And so I say it's that amount plus whatever the seller equity amount is.
So I always said what you're doing is you're taking a wrap and you're breaking it down into its two subparts, the sub two portion and the equity portion. Just like on your disposition side, you can make two notes out of that also.
Mm-hmm.
And so I told them to just figure the numbers and mash it into one note, really reconstruct it back into a wrap. But then the question of the amortization tables being at different speeds because different times. So I have to backtrack a little bit on that now and start creating these one double notes.
Well, and yeah, and so my note on the maturity dates, I have two maturity dates. I have the existing loan maturity date and the additional principal maturity date, and they could be different. So um, you basically, so an event of default would be failing to, pay the entire additional principal balance plus, accrued and unpaid interest and on or before the additional principal maturity date. And then the other one would be failing to pay the full loan balance on or before the existing loan maturity date. So you have two separate events of default and two separate maturity dates, if that makes sense.
Yep. So you took a subto note and a seller finance note and just shuffled them together like a deck of cards.
Yeah, basically.
All right. Well, good. Yeah, I'm glad to hear that, because that's what I was gravitating towards.
Interesting. If you're just joining us, this is the Creative Finance Collective. We're talking about all things creative finance. So make sure to post your questions. We're taking questions throughout the hour. Scott, are you with us? I heard you come back on.
I was trying to reboot, so I couldn't get the camera to work, and no luck.
Oh, that's okay.
Or maybe you guys are lucky, not me.
Yeah. Depends on how you couch that. I know you missed a little bit of what we were just talking about. Alan called these hybrid notes and structuring the performance part of the subto transaction as well as the equity side of it. What was explain the initial problem they were having you, Alan, want to do? They were wanting to make you or have you do two notes?
Yeah, so two promissory notes, one for the subto portion and then one for an additional seller finance carryback. And, I'm not scared of making money, but whenever I can make things more efficient and cheaper for clients, I'm usually doing that. And so I started gravitating towards one note, but had a problem with the more complex seller finance carryback, different interest rate, different maturity date, different, et cetera. But when possible, I was mashing those back together into one note. But now I think with y'all's help, I might be able to just create one size fits all, one note.
Hey, Alan, I got to ask you a goofy question. Why are you doing a promissory note for a subject to transaction? I get the seller carryback.
The reason is twofold. It can help that seller when they're wrestling with debt to income issue on getting a new loan. They can show that note and payment of that note obligation and payment of that note. And then also I'm trying to simulate as a regular loan package as possible in case we're getting sued for this, that, and the other. I want a note there that's obligating me to pay that other note.
I get that. And if I saw that, I'd probably be doing a mirror wrap, for lack of a better word. If I wanted to secure that differently out there. And the only reason I bring that up is, the investors out there, the reason they want to do a subject to is to limit liability. And of course, the moment you execute that new note, you are taking on that additional liability. And obviously, if the seller and buyer want to do that, I don't have a problem with that But typically under a subject to, the borrower is taking the obligation to make the payments pursuant to the terms of the initial deal. And I understand a seller potentially trying to look down the road for a refi and things like that. And underwriters are going to be goofy in how they look at those kind of things a little bit. I guess for me, I don't do that note between the seller and buyer on the subto the way you're describing. I think if I was going to do that, for me, I'd probably go ahead and do a mirror wraparound and go ahead and have a secondary deed of trust there. That just puts more teeth into it for the seller. But I get both ways. But on the back end, if the seller is going to carry back a second lien, so long as that second lien, it can really mature anytime they wish to do so along the way. I'm not objectionable to it maturing in 3 years, 5 years, 30 years, whatever it might be. It just means that if they're going to do a future wraparound mortgage, they need to deal.
Now, when you're saying mirror wrap, what documents are you drafting up for that if there's not a note and deed of trust? Scott, you there?
You still with us, Scott?
Well, let me jump in and I will say that from my perspective, I think it's important to do the wrap financing with the note and deed of trust. Our firm, I don't, but our firm does a lot of investor representation on the litigation side. And we had one not too long ago where this experienced real estate attorney was retained after closing. So the whole deal had closed. And, you know, he went in and wrote up this long letter about how this transaction was so horrible. And, you know, he used the term exotic and all of this. Never once did he reference the fact that there was a promissory note and deed of trust executed in favor of his client, securing our client's performance. Instead, he was like, what happens when they don't pay? And he went through all of this, made it seem like our client was doing this like out of the box, outrageous thing. And then we, pulled the deed of trust from the recorder's website, grabbed the promissory note and just like shoved it down his throat. And we were like, you've been around a long time. You know what a wrap is. This isn't exotic. This isn't unusual. Our clients just simply did a wrap. Your client's protected, go away. And there wasn't much he could do to come back from that. But I do think that, attorneys and even judges could potentially jump on just a straight subject to that does not have a wrap associated with it. And so I do think it's important to encourage clients and parties to a transaction to the investor to do that wrap, to give that, performance note and deed of trust so that, hey, the seller has some remedy, an expedited remedy, out of court remedy, if the investor doesn't perform as they've contracted to do.
Yeah. And I've had that occur 3 times. Attorneys roll in and say, apparently, some fraud occurred here and, the property was essentially stolen. And then I provide my 1911 letter, which shows that we all knew that it was a wrap. We signed off that it was a wrap or initialed 19 times. And by the way, you have the full set of loan documents protecting your client. And they always, well, I was going to say they bug out. I guess they learn.
They learn. They learn. Yeah. Yeah,
now,
exactly.
Did you come up with 19 disclosures just so you could call it the 1911 letter?
A little
You did.
bit.
You even cry. We got to get to the 19. It's just too good of the name for a letter.
Yeah. No, I don't know how it evolved there, but that's where it is now.
Yeah, the 1911. It's a good handgun. It's a classic. Interesting. Well, so if you're just joining us, we're doing the Creative Finance Collective. We'll be on here for 10, 15 more minutes. If you have questions, make sure to bring them. We have them and are there to answer them. What else is going on in the world of creative finance? The economy's not getting any better. In fact, I think they said October was the worst month of affordability on record this century. So
Wow.
beginning the 2000s, affordability has been the continuing problem, which would suggest creative finance is only going to continue to move.
I've always said, situations like this is going to cause mortgage wraps to get more in the mainstream. Agents are going to, have to shift and learn about this, and they got properties, days on market of 90, 120 days. They need to know how to go out there and sell this seller finance. And I've just kind of been sitting around waiting for it, but we're having mortgage guys shift with the market shift. and go out there and do agent outreach programs and trying to, they'll come in with the RMLO services and management services possibly, and then get them over to title to close. But I've seen just a fantastic increase in people trying to get this into the mainstream. And then some of the folks, it's kind of fun. Agents or even the sellers will come and start talking about how can I sell my property, and talking about this, and all they're talking about is a mortgage wrap. They just don't know it's a mortgage wrap.
Mm-hmm.
So I think for me, doing this for a couple, 3 decades, I think this time period is either going to be where it makes it to mainstream or it never will during my lifetime.
Yeah, you would think the conditions are such that we talked a little bit about this last week. During the short sale crisis, it's not like if you were to poll agents, they wanted to go be short sale agents. They didn't, but the conditions of the market were such that if you wanted to engage in real estate transactions as an agent, this is how you were going to have to do it. And it feels a lot like that now, in that as interest rates stay high and as home prices stay high, those two together create the affordability problem. And as that continues to go, it feels like the market will ultimately dictate where agents and these other professions have to go if they want to do a lot of real estate transactions. I think you're right. If these conditions don't create a push towards that, I don't know what else could.
Yeah. And does anyone think that the mortgage companies are going to go and start paying attention more to wraps if it does get deep into the mainstream?
Do we think, is that a facetious question or a serious one? Do we think that they're going to want to get in on it?
Well, are they gonna actually act on the due on sale clause? Are they gonna maybe make some examples out of people? I mean, I know they're not going to restructure their lender investment company over to a real estate investment company, but I'm just wondering if they would make a run at trying to say, hey, we really don't want y'all to do this, and we are watching.
Right. So how big does the market have to get before lenders would try to start making an issue out of it? Is that the kind of the idea?
Well,
Yeah.
Being the old goat here of the group a little bit, although a few of you might be catching up with me, I go way back to the inception of my days, and you just didn't see the lenders doing that. Even when rates were at 16, 17, 18%, you thought or rates, you thought that they would call the lower priced loans due out there so they could put the money back out at a higher price. They just didn't do it. I think the lenders out there, once they have closed the deal, they usually don't portfolio these loans. It's always usually out in Wall Street somewhere, and they're servicing the transactions more or less. The deal's done. They just want to collect the money and not have any negative issues. And the stats I have seen over the years say that when lenders foreclose on properties, they lose tens and tens and tens of thousands of dollars out there. And it just becomes problematic. I know we've talked a bit about Arizona and how it works in y'all's jurisdiction out there, that they really don't have the right to call a loan due. But man, I have seen so few due on sales, it's not even funny. And so unless something is really going awry and there's a problem somewhere, I don't see lenders doing it. I don't care what the situation is. I think bottom line is, as we all know, they just want their money. And I think as long as things are working smoothly, they're going to be okay with that.
I agree. There's some the sky is going to fall, folks out there, but I just can't see a restructuring of the lenders instead of collecting their money to cause problems so they're not getting money.
Yeah, I don't see that happening. I mean, goodness knows, guys, anything can happen, right? And it has, but I just don't see that happening.
Well, I think they face another problem too, especially when you're talking about people's homes, it's a PR problem. If lenders did this in a large scale to try to make the kind of point that you're talking about, Alan, I think that would be bad. Where we would be economically for that to have to take place, I think would be, I don't know. Seems to me it would be a big PR problem. They would be better suited to just maybe either change policy. Here would be the interesting thing. In order to gin up more business, could the policy change be less about calling loans due and going back to a system where they allow the assumption of mortgages? Maybe that's the shift.
So what I'm waiting for personally is, especially the credit unions, I've seen sometimes they're a little bit more concerned or aware, but to have them call that due on sale, then do my deed flip flop back and forth to get back into compliance by deeding it to their borrower, and then when they find out about that, and send another due on sale clause notice, default letter notice, then meet with them and say, I'm going to do the same thing every time. There's absolutely nothing you can do to stop me. So let's talk about a qualified assumption, please.
Yeah.
No, so Alan, I think the big mortgage companies will have more of an issue with that than your small guys, like a small commercial bank or a credit union, where they actually control the deal. So if you're dealing with a portfolio lender who actually portfolios that loan and controls it, I think that could be a viable option. And you're exactly right. You can play that game ad infinitum with them. And eventually they're going to give up and go, so long as you make your payments, we're happy.
Yeah.
I don't think any lawyer is going to take that on risk and have an issue with that. But I think the large lenders, because they don't have that ability, they could. So I don't. That's just one of the things that becomes problematic, I think, over time.
So are you saying that the larger lenders don't have that ability for the same reason they wouldn't call the note due with the due on sale clause, because they've packaged it and it's on Wall Street and they really just don't have control over it anymore?
Well, they have to follow supposedly their set rules that they've been given when they portfolio those packages out to Wall Street somewhere and sold them. It's like if you ever talk to these guys, it's like they're just reading the script.
Right.
And you may as well talk to the wall, because that's about how much response you get back. But in Alan's point, when you're dealing with a credit union where everything is portfolioed, or you have a small commercial bank, and by the way, commercial banks love this stuff because they know they got two borrowers to repay their loan, and they're still in good lien position because they actually think for a living. And I just think that your large lenders who package off the loans to Wall Street somewhere and just wind up really servicing the loans more or less for Wall Street, they don't have the same flexibility, in what Alan is speaking about, that these smaller guys do.
Could you see a scenario where the government tried to cram it down and force the big lenders to cooperate and provide avenues for things like assumptions?
Well, I see it the opposite way. We were just a few pen strokes away from the Texas legislature stating that we had to get permission from the underlying lender for the wrap to occur. They thought that was possible, and we had to educate them. My quote was, "Who are you asking, Mr. Wells or Mr. Fargo?" And do you expect to get an answer? And so they were close to requiring that. So I don't know. I see it that way versus forcing the lenders to do it.
To Alan's point there, guys, here in Texas, when you do a subject to or a wrap loan, and especially if you do a wraparound mortgage, oh gosh, where was I going with this? If it doesn't close in a law office or a title company, it's void. So that's one of the things they put out there on us just recently, and some other miscellaneous disclosures along the way. But They've already got a few
But-
things out there on like options where you may have to get a underlying lender's permission to do it, which makes no sense at all.
Yeah.
But, you know, I can't even imagine trying to get an underlying lender's permission to do this. Credit union, small commercial bank, maybe. Your larger banks that have, you know, closed these things and then sold them off and are servicing, not a chance in hell.
And those disclosures that you're talking about, if you fail to give that disclosure, and then you go and try to foreclose, and some lawyer says, "Well, look, you didn't provide that disclosure." Doesn't matter if it's 5 months, 5 years, or 30 years. That borrower gets to rescind the transaction and put the parties back into a place they were in before the contract. So it's serious if you don't do it
And
right.
get all their money back.
Yeah.
All
Yeah.
their money back. You know, so
Yeah.
I'm waiting for that court case to come up. Hopefully it's never involving me anywhere or any fashion, just to see what really happens at the end of the day.
Yeah. Yeah. Well, hey guys, appreciate you taking the time. We've been here just about an hour. Good discussion, good talk. You guys probably have.
Did Elizabeth say more than 2 words again?
Well, she's preparing for trick or treating tonight. You know.
Yeah.
Can't
You know, I
be-
told her when I was there the other day, you know, I was going to pull this out of her somehow. I didn't do it, but next time,
Yeah, she was worried you were going to grill her.
yeah, we might have to do that.
Yeah. All right.
Al and I will team up on her. Okay.
Yeah.
All right, guys. Well, enjoy your Halloween with your families, and we'll see you next time.
See you guys. Good
Thanks,
seeing
guys.
everybody.
All right. We'll talk to you later.
We'll see you
It
later.
won't be a Casper,
Everyone.
hopefully.
All right.